Counsel, you understand we have this hearing, a couple other hearings, and we're in the middle of trial. It is, okay, the court's going to have to evaluate sanctions in your pro hoc vice application, okay? If the straight Supreme Court rule, did you read the memoranda?
Good morning, Your Honor. This is Nushan Nuri. I'm associated as counsel for Costco.
And you filed your notice of remote appearance?
I apologize, Your Honor. I believe I don't believe I have.
And how can you appear audio-visually under the Supreme Court rule, right, when you haven't done that? How can you appear for this hearing?
I will not make that mistake again.
Well, counsel, that's not my question, right? My question is, the Supreme Court rule, right? Are you licensed here in Nevada?
No, I am not. I have a local counsel.
Pardon? You're not?
I am not. I am not licensed in Nevada. I was recently admitted in this matter.
Okay, so where's your local counsel?
He is not an attendance.
How can he not attend? Specific Supreme Court rule requires local counsel to attend all hearings and matters.
I can't speak to him as to what here.
Okay, we can't even hear you, okay? The other thing with remote appearances is you have to ensure that you have the appropriate equipment that allows you to appear remotely. So, counsel, you cannot appear under our Supreme Court rules. You're violating a Supreme Court rule. You're violating your pro hoc vice, right? Do I have to withdraw your pro hoc vice because you choose not to comply with the rules?
I apologize, Your Honor. I was not aware. I'm sorry. I was not aware. It's my mistake, and I had not. I just didn't know. And
who's your local counsel? Okay, first off, we can't hear you, and that's going to completely interrupt the transcript and everything. Who is your local counsel, please?
Michael Federico.
And why is he not on the line? Did you tell him he could not be on the line? Did he tell you he was not?
I did not.
Or what happened?
No, I did not. He received the same notices that I do for this case.
Okay. Was there any
I can email him.
communications?
I can email him at this right now and try to reach him.
Counsel, you understand we have this hearing, a couple other hearings, and we're in the middle of trial. It is, okay, the court's going to have to evaluate sanctions in your pro hoc vice application, okay? If this is really a challenge. It's straight Supreme Court rule. Did you read the memoranda? The memoranda that you received in order to get the login link, right?
Yes.
Okay, take a look at paragraph 2, the bold paragraph, the one you have to get through in order to get to the link.
Yes.
Counsel, do you see
I'm sorry, Your Honor.
Do you see what that says? Counsel, do you see what that says?
I do. I do see that right now. I'm sorry. I did not. I'm sorry. I just did not know of this appearance until last minute. I'm very sorry. I promise that I will never make this mistake again.
But
it's my fault. I should have been more. I should have been careful. I should have not done this. But it will not happen again, ever.
But the counsel, it's clearly there in bold, right? Please note, it's bold all caps. Note double asterisk. In bold, please be advised that any hearing on or after May 30, 2022 must comply with Administrative Order 22-7 and Nevada Supreme Court Rule Part 9, A and B, rules governing appearance by telephonic transmission equipment and rules governing appearance by simultaneous audiovisual transmission, period. Current administrative orders and forms for audiovisual appearances may be found at the court's website. We even give the website. We even give you the link. Then we put in paren, please see Administrative Order 22-7 and Supreme Court Rule Part 9, A and B to ensure full compliance. So you can appreciate the court's concern because now I'm spending time, which A, other counsel and their clients are being charged money. B, I've got other matters on the calendar, including a trial. And C, it's right there. If your pro hoc vice application specifically stated that you would comply with all the rules in Nevada.
I understand. I made a mistake that I should not have made. It's my error for not properly reading this notice and understanding the gravity of the situation and compliance.
Gravity of complying with the Supreme Court rule, counsel?
Yes, I think it's very important. I did not appreciate. I understand that it's very important. I did not comply and did not properly communicate with my local counsel and understand this issue. I apologize.
I'm sorry. I guess and the reason why I'm asking is because we think this is plain English. First off, everyone has to know it. B, it's in the memorandum, but we don't have to put it in there because people are supposed to be aware of the Supreme Court rule and the administrative order in order to practice here, both local and pro hoc vice. Then we even give you the extra courtesy, and we not only send a memo instead of just having you go and find the link on our website, and we put in bold so that everyone can see it. And we give you the administrative order, the Supreme Court rule, we even give you the link to where you can find it. So you can appreciate the court's not understanding how, other than just choosing not to read it or choosing to not comply. Okay, so the court's going to do a hearing on your pro hoc vice status, counsel.
Okay, I understand.
I'm going to have to do it, and you are not, okay, so you've got two choices. I mean, I'm going to have to do it. You've got a double violation here. 2 Supreme Court rules, right? Local counsel must appear. That was in your application packet that you did an affidavit on, counsel.
I did. I did not understand that my local counsel was not appearing. Because given that he's local, I didn't know that he would not appear today.
Wasn't it your obligation to ensure that he appeared? Counsel, isn't it your obligation to ensure that he appeared?
I believe he has the same obligation as knowing being a Nevada lawyer and being admitted as counsel for Costco in this case.
Supreme Court Rule 42, right? Your application, I'm double checking on it. Is very, very concerning. The court will do a hearing. I'm going to have to set that at the end regarding whether or not you get to maintain your pro hoc vice status or the per se noncompliance with 2 specific violations of 2 specific Supreme Court rules, even given you got a memo that told you about it. So I'm not sure what you're going to do, but we're going to keep on going because everyone's waiting, and now it's taking extra time, and we've got counsel and other matters already here and appearing, and that's not fair to them. Okay, Real Water.
Good morning, Your Honor. Joel Odou on behalf of Affinity Lifestyles, Inc.com, DBA Real Water, and Real Water, Inc. I filed my notice to appear audiovisually on August 19.
Thank you so much. Okay, you're also Real Water, Tennessee, LLC, counsel?
Yes, Your Honor. I apologize. I forgot that entity is also in this case.
Okay, yeah, okay. So I'm going to one more time say Milwaukee Instruments. This is a court-ordered hearing, folks. Anyone Milwaukee Instruments? Elizabeth Lowell, Robert Robbins, Robert Mulligan. Anybody? There's nobody here in court? There's nobody online. Okay. There's one more person who has not identified themselves. Would you like to make an appearance? Are you on this case or are you here for another case? I want to make sure I've taken care of everyone on Richt versus Affinity Lifestyles, DBA Real Water, case 831-880. Is there anybody else needing to make an appearance? I'm not hearing anybody else making an appearance. Okay, so, counsel, the reason why the court needed to call you in is you can appreciate this case and several other coordinated cases are all back from remand. This department has multiple of these cases. So what we need to know is, and that's why it's so very, very important that we have all parties, right, appropriate lead counsel so they can discuss these things. So, and that means we have to have local counsels, etc. So anyway, we need to determine from a move forward. Normally, at this juncture, you all have a special master, but the special master is for discovery and those coordinated pretrial matters. We do not, based on the 10/18/2021 document filed in the lowest case number in front of Judge Alf, it specifically states that each of the departments are to set their own trial dates, which is what we were going to start doing. We are also appreciative that to start setting trial dates that may impact similar counsel or some of the same counsel in other cases, not only in front of this department, but in front of other departments. So what this court does not know is if whether or not the appropriate counsel have communicated with one another and you all have a suggested game plan on how to do these trial settings, which is why I wanted to give everyone an opportunity. And rather than calling them in multiple cases, I figured I'd do one because I got most of the same counsel. And then if we need to do other ones, we can walk those through as well. So that means I'm either going to hear from probably Mr. Pepperman or Mr. Odou, who's going to go first and kind of tell me the thoughts.
Your Honor, this is Eric Pepperman. I can address it. First, for the...
Pepperman on behalf of plaintiffs, sorry. Remember, each time you need to state, because in order to get to your appropriate record. Thanks. Go ahead, please.
Apologize. Eric Pepperman for plaintiffs. And also to correct the record, I double-checked. We filed our notice of intent to appear via audio-visual means on August 19th. I misstated it earlier. So your Honor's concerns about the trial setting are well taken and appreciated. The status right now of the coordinated matters is that we have commenced initial discovery. Written discovery has been exchanged. The largest holdup that has kind of delayed any type of formal order or scheduling order that would, I think, be necessary before we start looking at setting the trial dates in the different cases is Real Water's been going through a substantial number of documents and preparing to disclose those in a document depository that we have set up with Holo Discovery. They're in the process of doing that. We've been communicating on it and meeting with the special master on it. I think it's nothing more than it's just a lot of documents to go through, and the logistics of producing it all and scanning it in is just taking time. But I can let Mr. Odou comment on the timelines, but our understanding was we were expecting a production soon, an initial large production of those documents soon, and then a second production and perhaps some rolling productions after that. At the same time, we have agreed on fact sheets for plaintiffs in the coordinated cases. There's over 60 of them. My office represents close to 60 individuals, and so it's just a time-consuming task to go through and collect all the information and with respect to the individual plaintiffs and have them review everything and sign everything. We've produced about, I think, 13 fact sheets for our clients. We have another 13 to 15 done that are close to being produced, and we're working on the rest. I think once this initial kind of task of making sure that all the Real Water documents are in the depository and the plaintiff fact sheets are ready, then at that point, I think the plan is to have a better idea of the schedule and to get a scheduling order in place with Special Master Hale. And then at that point, I think we'll be able to start identifying different potential trial dates based on that schedule.
Counsel, I'm going to stop for a quick second because I don't know if have you recently read the special master appointment, right? And the scope and breadth of that. It doesn't cover. Yes. It doesn't cover setting trial dates, right? It's not like a CD. Whoever's coming on, please make sure you mute yourselves. Please, you're interfering with another hearing that's currently going on. Thank you so very much. Okay, somebody else still has not muted themselves. Somebody's echoing.
Judge, I believe is Ms. Lowell from Milwaukee.
I'll take care of that in a second. People show up late. Thanks. So, I'm sorry, circle back, but when people log in and don't mute themselves and they have feedback, unfortunately, it interferes with the hearing. Okay, so, counsel, the special master said, parties agree special master should hear all matters related to pretrial discovery, perform additional duties, or directed by the court, right? But specifically says the court is to schedule all the trials. So I was starting to say before the noise, it's not like a CMO on a CD case, or as you've been involved in other complex cases, right, where the special master's role as defined includes creating, a variety of different scheduled trial dates. Also, I don't see anything here that people have anyway addressed the issue of the mandatory Rule 16 conference, right? I don't see any request deemed complex to have this outside of the rules, etc. That's why there's some challenges in this case. When I use this case, I'm going to use the one that's currently before me, but you can appreciate if I had a similar status check, I'd be probably saying very similar things on the other cases. So when you say you want to do these things and then have Special Master Hale kind of schedule trials, doesn't this court have to call you in for Rule 16, get a trial set, because there's nothing that shows any exceptions, exemptions, and your own order says Special Master Hale only does the pretrial discovery stuff?
Well, Your Honor, I don't know the order that closely, but to my best recollection, we did stipulate to designate the matter as complex and appoint Special Master Hale in the same stipulation and order, and delegated the responsibility for the initial conference and case management order to Special Master Hale as part of the stipulations. It was certainly our intent to put that in front of Special Master Hale. If the stipulation is insufficient to accomplish that, I certainly can understand that and would apologize for that. But our intent was to have Special Master Hale handle the case management order, initial Rule 16 conference aspect of the case. In terms of trial setting, you're correct. We specifically left that in each of the individual departments because of the coordination as opposed to consolidation, as the individual departments over each case will hear the trials in the matter. And in terms of scheduling the trial, we're open to whatever is most convenient for the court. If the court would like to get a date on calendar now, we're open to discussing those dates or scheduling. If the court would prefer to allow us to get past this initial kind of tranche of organizing all the documents and discovery, and then entering a scheduling order and case management order with Special Master Hale before discussing trial setting, we would understand that as well. It's whatever's convenient for Your Honor, and in any way that we can help facilitate that, we are more than willing.
Sure. And counsel, what I would direct everybody to is what the court's looking at, and if there's something else I should be looking at, because remember the court did inherit this case and reviewed this and several others. So I appreciate that there was the intervening federal action before we met. So 5/24/2021, right? Signed by Judge Gonzalez, stipulation order to designate the matter complex and appoint Floyd Hale, Esquire, Special Master under NRCP 53, right? So then it says the coordination order is attached. Okay, fine. Actually, it wasn't, but in any event. Then it says what is going to be Special Master's duties and authorities. Must proceed with all reasonable diligence to undertake these responsibilities to avoid dispute. Okay, that's interstate language. Timeframes, unless agreed by the parties or ordered by the Special Master. Parties should have an initial meeting or remote conference with Special Master within 14 days of issuance of this order. During the initial meeting, the parties and Special Master must formulate a plan for completing pretrial discovery, including without limitation, entry of discovery plan, and schedule order. That takes you through discovery, right? And I appreciate certain things may not have happened because of federal court, which is why I asked you all here so we can get this taken care of for y'all. And then it goes into the right that they can have ex parte communications, materials to be preserved, review of the orders, and compensation. Then going to the attachment from Judge Alves, right, which was the stipulation, and that was what I was referencing earlier. And at that time, there was the 9 cases, 8 of those by your firm. And then it says, although they involve separate and distinct plaintiffs, individual personal injuries, and some unique defendants, Real Waters are the same factual. So you said coordinating or consolidating, and then it said for paragraph 9, the parties therefore agree that Real Water cases should be coordinated for pretrial discovery purposes only, and that the trial, as well as any trial-related or other case-specific matters, e.g. amendments, dispositive motions, trial scheduling, motions limiting, etc., should be heard by the separate judge assigned to each case. The parties further agree that the individual departments should remain responsible for scheduling the trials in the cases before them, irrespective of any impact on the coordination or this coordination order. That's what I'm looking at, right? So that's why you all are here, because I have that affirmative obligation to get cases to trial, right? And realize, though, that you have probably coordination aspects with multiple cases. So let me hear from Mr. Odou, and I'll circle back to other people as well. Go ahead, Mr. Odou, please.
Thank you, Your Honor. Joel Odou on behalf of Affinity Lifestyles Inc.com, DBA Real Water Tennessee, and Real Water Inc. I agree with Mr. Pepperman. We've been meeting with the special master approximately every 2 weeks to coordinate discovery. Our next meeting with the special master is set for September 12th at 1 p.m. We are now coordinating approximately 22 cases, or there soon will be 22 cases in various departments in the 8th Judicial District. There's 1 case in arbitration, and I think that's the totality of the cases. Due to the Real Water bankruptcy, we were unable for a substantial period of time to access documents that were in a warehouse in Mesa, Arizona. Those documents have been transferred to Nevada. They are now at a document repository and are being dealt with. There's approximately 400 boxes of documents that came from Mesa, Arizona. There was 200 plus boxes of documents that were here locally. And so while the parties have all done their initial 16.1 disclosures, discovery is going to be complex. And in addition, I would just add that we are looking at a lot of depositions that will be coordinated with the special master. Our suggestion to the court would be for the special master to issue reports and recommendations on the status of discovery to advise the court, and certainly the parties can meet and confer with the special master on September 12th to work on those report and recommendations, and that would give the court an idea of when this matter and other matters can be set for trial in the most efficient manner possible.
Okay, because you appreciate, I don't have anything from, you know what I mean, on this. So other than your stipulated protective order, I should say, and a couple of requests for pro hoc vice. Okay, because has there been any CMO or anything?
Yes, Your Honor. There's been a series of special master orders and reports. They've been filed in the lead case. I think that we overlooked the fact that they need to be filed in every case, and I think they eventually get filed in every case. But there's been. They have not been filed in this case.
You all need to ensure that they get done in every case, right? Because since, remember, these are coordinated, since they're not. So I will tell you, you got the same access as I do, just called something different. Realistically, I could not find a single entry since remand of anything going on in this case. That's why I had to call you all in, right? And I wouldn't, if something's filed only under 1 case number, I wouldn't go searching to try and find it, because remember, it's not supposed to not necessarily apply to Department 31's case unless it specifically says it is. And since these have different trials, dates, and all those things are handling by the trial judge, you're not going to get these filed in every case unless you all do it. So, okay, So are you saying that there's a CMO in this case that says when discovery should be completed by?
No, Your Honor, there's not a CMO per se. There have been various orders about certain productions, orders about depositions, but it's not a consolidated CMO like you would see in a construction defect. Instead, there's been a series of discovery orders and discovery disputes resolved by the special master, and that have been across the board. And so we will ensure that those orders are filed in this case so the court can see that substantial progress is being made.
Right. And remember, the court's not really questioning the substantial progress. The court has obligations to get these cases to trial. These do specifically say that the court has to address all those trial issues, so, and other things like dispositive motions. Generally, in taking CD as the easiest example, you know, we set trial dates. First we get like a draft CMO, then we set trial dates, and we get that taken care of. So I've got two ways to do this. And let me see who else I can talk to. Those are the only parties that made a proper appearance, because I didn't have, actually I'm incorrect. Mr. Spurlock, on behalf of your clients, do you wish to provide input?
Your Honor, I have to agree with counsel. We've been coordinating and working together, I think, well. We have multiple supplemental disclosures that we're in the process of making as well, and I think we've been coordinating with plaintiffs' counsel. So I think everything that's been related to the court, I'm totally agree with. I just can tell you the court, there's multiple documents, hundreds, if not thousands of pages of documents, and we're all coordinating and trying to get this done.
But you appreciate the back end of that is these all are going to go to trial, and we can't have, oops, all of a sudden, guess what? We've got to try and get all these cases to trial, right, without some advance scheduling of where those trials are going to go, because aren't each of these trials anticipated to take more than just a few weeks?
I think that's correct, Your Honor.
Mr. Odou, would you agree on behalf of your clients that they're scheduled to take more than just a few weeks?
Yes, Your Honor.
Pepperman, would you concur on behalf of plaintiffs?
Yes, Your Honor.
Okay, so you understand where I'm going is don't want to have, look, all of a sudden a situation we've got to have a whole bunch of cases tried and taken care of without kind of getting your nice advanced scheduling, which should hopefully be what the parties want and what needs to happen. So realistically, here's what I think you're asking the court to do. What I think you're asking the court to do, and I'm not going to anybody who's not made a proper appearance because you can't speak. You can observe, but then we'll have the violations of not being here as part of a court order status check. But okay, so in any event, I really have two options. One, I can give you a trial date in this case, and then you all have to work to make it work with regards to your discovery. That doesn't seem to be the most practical option, but if that's the one you all want, let me know. Choice two appears to be that I give you a deadline by which I need a CMO on this case, and I can either issue minute orders for all the other cases in Department 31 to give similar deadlines just for my CMO so I can do some advanced planning and scheduling, right? Or I can call in each of the cases here in front of Department 31 and go through the same thing with each of the cases in Department 31. So it's kind of a multi-pronged thing. One is, do you all want me to set a trial date today and then you work your discovery off of that? Or do you all want me to give a time frame by which this court needs a CMO with a suggested trial date through your special master? And then I may need to do a second hearing just to confirm with this and the other cases here in Department 31. And then an independent question is, for those of you who are on multiple cases, your thoughts on the court issuing minute orders on what needs to be done versus calling you in on each specific case here in Department 31 and asking you basically pretty similar questions. So plaintiffs, you've got a lot of these cases, more than one in front of this department. I'll let you go first, then we'll circle around.
Thank you, Your Honor. Eric Pepperman for plaintiffs. I think that the most efficient, practical option would be to give us a date as a continued status check on this and allow us the time to address a scheduling order with Special Master Hale. I think that is the most reasonable way to ensure that, we're lining up the trial date with the realistic schedule based on the parties' discussions with the Special Master.
Okay, and then the second question, and since you represent multiple plaintiffs in more than one case in front of this department, are you going to request that you wish the court to call you in specifically on each of the cases? Or would you find it appropriate, at least from respect for your clients, not speaking for anybody else, that the court issue minute orders on status checks consistent with what I do in this case to try and give each of the cases in front of Department 31 an opportunity to work through what they need to work through before we get you a trial date?
I would prefer the second option with minute orders in each case. That would be acceptable to plaintiffs.
Okay, because if people want to come in, I'm more than glad to have you in. I'm also trying to be cognizant of your time and your clients, paying and everything, and not just redundancy, but okay. Let's go to counsel for Affinity et al.
Thank you, Your Honor. Joel Odou on behalf of Affinity and the real water entities. We would prefer that we get the case management order with recommendations from Mr. Hale. We will be seeing him very shortly and can add that to the agenda. And then as a second option, we would agree with Mr. Pepperman that those recommendations can be made in all the cases before the court. And if the court sees an issue with them, the court certainly would call us in and we can talk about if there's an issue, whether it's timing when a recommended trial is set or, the court's calendar, obviously.
Okay, so you're not requesting on behalf of your clients to come in for each case in front of Department 31 and go through this type of status check? If you are, I'm more than glad to do it. But...
No, Your Honor, I am not. And I'm also not requesting a specific trial status check unless that's something that we need to do, because these cases are quite lengthy, and I anticipate Mr. Hale would need to communicate with the court as to when they could be set, when the court is available, or the parties could. I'm just trying to problem solve so we can be most efficient.
I think we're all on that same page of trying to get this case where it needs to be, but not let things just sit out there because of all the rules and different deadlines. Okay. Well, Mr. Spurlock, your position on behalf of your clients.
I agree with counsel and Mr. Odou with just what he had to say, Your Honor. I think that's the most efficient way to handle these cases.
Okay. So everyone who's made a proper appearance, I've addressed. So that means you're seeing Special Master Hale on September 12th. Looks to me like I'm going to see you all in early October to give you time from after the Special Master hearing to get together and to coordinate these CMOs. And I'll do a status check on the CMOs in the trial setting so that we can get that taken care of and we can address it. And what I'm understanding from the parties, that it was intention that since Special Master Hale is doing discovery, that he's going to be understanding is going to do a CMO on each of the cases in front of Department 31. There's no need for this court to do a Rule 16 conference. Does anyone disagree with that? If I'm misunderstanding it, please let me know. If you concur that you don't need a 16.1 from Department 31, please let me know.
Joel Odou on behalf of Affinity and the real water entities, we agree.
Agree you don't need a 16.1 from Department 31? Is that correct?
Yes, Your Honor, that is correct.
Thank you. We have plaintiffs?
Eric Pepperman for plaintiffs. We also agree that there is no need for a Rule 16 conference in Department 30.
31. Okay.
David Spurlock, we'd agree as well.
Okay. So the parties have made appearance. Okay, so we're not going to call you in unnecessarily. That's not worth anybody's time. Okay, so.
Your Honor, this is Michael Stoberski for Costco. I'm sorry, I came in late. We have no objection to no Rule 16 conference either.
Thank you, Mr. Stoberski. This was 8:30. It's 9:04.
I apologize, Your Honor. Somehow our office did not have this on calendar.
What's the date you filed your notice of remote appearance, counsel?
Yeah, and I also have to apologize, Your Honor. We weren't aware of this hearing, so therefore we did not file our request for electronic appearance. So I'd have to ask the court accommodate that request orally today.
I can't.
If we had known about the hearing, then we would have made that request.
Counsel, I'm sure you know this from the other cases in this department, as well as this case. Did no one bother to read the memoranda that was e-served on every single person? Document 110. E-served on all counsels in this case. Anybody who signed up for electronic filing, right? Department 31 memo that says that nice bold paragraph is the second paragraph, which I've already read once, right? Which references the administrative order. Well, note, please be advised that any hearing on or after May 30th, 2022 must comply with Administrative Order 22-7 and Nevada Supreme Court Rule Part 9, A and B. Rules governing appearance by telephonic transmission. Who else can open the memo? right now. Okay. Rules governing appearance by telephonic transmission equipment and rules governing appearance by simultaneous audiovisual transmission equipment. Current administrative orders and forms for audiovisual appearances may be found on the court's website. We give you the court's website. Then we also put that in paren. Please see Administrative Order 22-7 and Supreme Court Rule Part 9 A and B to ensure full compliance. Counsel, you asserting that your firm did not get that memo that was e-served on all parties in this case?
No, Your Honor, we're aware of the requirement to seek permission to appear electronically. The point is we were not aware of today's hearing for which to ask for permission to seek electronic appearance.
Counsel, the top of the memo, subject, in bold, all caps, remote appearance information for hearing scheduled on August 25th, 2022. Double asterisk, please review entire memo, double asterisk. Then in nice bright red, we say, please note Department 31 is now located in courtroom 16B. That's the memo this court's referring to, electronically filed and served on everyone. 8:24, 8:16 a.m., but we really didn't have to do the memo because this hearing was also noticed, right? Clerk's notice of hearing. 7, let's make sure this is the right one. There was also a second memo we sent at 1:11, which did mention there was the time change. That also was sent to all parties and all counsel, right? Counsel or parties. Currently, there's a status check on trial scheduling set before the court on August 25th, 2022 at 9 a.m. However, due to the fact that it's a business court matter, it should have been set at 8:30 a.m. Therefore, the status check regarding trial scheduling reheard, bolded, and underlined, August 25th at 8:30 a.m. A memo containing the road appearance information has already been filed. Please feel, if you have any questions, please feel free to contact me at my JEA. But we also had a notice of hearing, setting this hearing before you even got any of those, which realistically I now got a courtroom full of people and I've got trials, so I'm not going to go find that exact document. So there were 3 notices of today's hearing, e-served on everyone who has signed up in this case. So, counsel, I'm hearing what you're saying, but you can appreciate that unless you failed to sign up for electronic service in this case, which would be a different violation, right? Then you would have gotten the emails. You would have gotten all these services, right?
Well, Your Honor, I'm at a disadvantage. My assistant is the one who provided the information to me that we did not get the notice of the hearing, and so we'll certainly investigate that to make sure we had proper notice. And if we did get notice, then I apologize, and I'm asking for the court's understanding under the circumstances.
But counsel, it's I'm a district court judge. You know the fact that these are Supreme Court rules and administrative orders that I, as a district court judge, have no option but need to follow. So, I'm asking when they opened it. Okay, hold on. 1 second, please. Well, I just had my assistant, my JEA, go pull up the Odyssey file and serve. It shows it was sent. If people, in fact, a Cindy McCullough opened it. There's Cindy McCullough at your firm?
Yes, Your Honor, that's our legal assistant.
Well, Cindy McCullough opened it. It was also sent to Mr. Federico. He chose not to open it. But
we'll look into what happened, Your Honor. I apologize.
Okay, so counsel, you can appreciate I've got different issues. You also realize that no one was on the phone and your out-of-state counsel said they weren't informed about the administrative order. So I'm having to have a hearing regarding her pro hoc vice status for double non-compliance because she got the same memo, two memos from this court. Appreciate the court has to follow the Supreme Court rules, folks. So in any event, counsel, for you, I'll put you on the same date for an order to show cause, okay? So that people have an opportunity to explain, and I'm not holding up the 20-some-odd people in my trial that all need to be taken care of in fairness to every other case. So,
John, is that hearing?
I have no idea who's speaking over me when I was talking.
This is Nushan Uradini. I was asking when the hearing for the order to show cause, when you're setting that.
We're going to set it. You'll get notice of it. Right now, I have to finish up today's hearing right with a date for the status check. Can appreciate this has now taken 50 minutes because of having to deal with the administrative stuff rather than dealing with the 5 minutes that really 5 to 10 minutes that the status conference report takes, or because of the non-compliance issues, counsel. So let me get you a date. I was starting to say in October, so that I give you time after you see Special Master Hale. I think if I give you 30 days for Special Master Hale, usually spend sufficient time in other type cases. Is there any reason doing the status check on the CMO 30 days after you see Special Master Hale? So I do it on October 13th at 8:30 a.m. Is there any reason that that's not sufficient time for everybody? Counsel for plaintiffs first, please. Counsel.
Your Honor, Eric Pepperman for plaintiffs. I think 30 days should be sufficient time. Confirming that October 13th works for me.
Affinity counsel.
Thank you, Your Honor. Joel Odou on behalf of Affinity and the Real Water entities, October 13th works for us. Thank you, Your Honor.
Whole food entities.
Your Honor, it works for us as well.
Okay, Costco.
Michael Stoberski, that's fine, Your Honor.
Okay. Is there anybody else who hasn't provided position? Those only people that either have made proper appearances or improper appearances that the court's aware of. Is there anybody else the court needs to address? Anybody else on this case? No? Okay. What we're going to do is we're going to set day August 25th. Okay. September 9th, 8:30 a.m. is going to be the order show cause, and OSC will go out. And that would be for pro hoc vice status of Costco counsel and noncompliance with the administrative order, and also for out-of-state counsel. Well, not having local. I have to address all the issues with regards to Costco. I'm just going to leave it at that. We'll deal with that on a date at 8:30. Everybody heard me? Yes, who that applies to? No one else needs to appear, although, of course, people are more than welcome. It's a public courtroom. But I do need local and out-of-state counsel for Costco. Okay? At that 8:30. First one. So anything else the court could do? Anything else the court could do for you on Richt versus Affinity Lifestyles et al. Case 831880? Anybody else? Anything else? Plaintiffs, anything else?
Eric Pepperman for plaintiffs. No, Your Honor. Thank you very much.
Real water entities, anything else?
Joel Odou for Affinity and the Real Water entities. Nothing else. Thank you, Your Honor.
Whole food entities, anything else?
Nothing else, Your Honor.
Costco, anything else?
Nothing else, thank you, Your Honor.
Thank you so much. That completes the matter. It's 9:15. Okay, sorry, people who've been patiently waiting for your 9 o'clock matters. We're going to call first the